I'm really sure I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a big gun at my house. I need an officer to come to my house.
As we finish the trial of Jennifer Crumbley, we now start the trial of James Crumbley, the father of the Oxford High School shooter. Could he be found criminally responsible for the actions of his son? This is a recap of Day 1. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, let's talk about Day 1 in a brand new trial out of Michigan that may actually seem kind of familiar to you. I say that because this is the trial of James Crumbley, the father of the then 15-year-old Oxford High School shooter who killed 4 students and wounded several others in a horrific shooting back on November 30th, 2021. The victims, Madison Baldwin, who was 17 years old, Tate Muir, 16 years old, Hannah St. Juliana, 14 years old, and Justin Schilling, 17 years old. And while the shooter ended up pleading guilty to 24 charges and was sentenced to life in prison, now we had a question about his parents. And I said this trial may seem familiar because both of the shooter's parents, James and Jennifer, were charged with 4 counts of involuntary manslaughter, representing each victim in the case. Now, they are the first parents in American history to be held criminally responsible for the actions of their child in a mass shooting. And in keeping with this landmark history-making decision, last month, Jennifer Crumbley was found guilty. So now we move on to the trial of James Crumbley. And I will tell you, in many ways, in my view, the case against James Crumbley is worse than Jennifer. And we're going to get into why. But to be clear, when we talk about involuntary manslaughter, a charge that carries potentially up to 15 years in prison, there's a question of whether or not if he's convicted of all 4 charges, he would serve those sentences consecutively. Could that add up to 60 years? That's a conversation for a different time. But there are 2 theories for the jury to find him guilty of involuntary manslaughter here. Either James Crumbley committed a grossly negligent act causing death. These people died as a result of him storing the firearm and ammunition so as to allow access to his child. This is gross negligence. It's willful disregarding the risk to others, that he knew of the danger to others and failed to take ordinary care or appropriate care. That is one theory. The alternative theory by which they can find him guilty of involuntary manslaughter is that Crumbley was grossly negligent in performing a legal duty that he owed to these victims, that a parent has a legal duty to use reasonable care to prevent their child from harming others or preventing their child from creating an unreasonable risk of harm to others. Again, willful neglect, willful failure to fulfill that duty. So a big theme here was that what his son did was foreseeable and that it was preventable. So with that in mind, we heard the opening statements from the prosecution and the defense on Day 1. And to start off with the prosecution, because they go first, it's their burden, it's their case, here is Mark Keast.
November the 30th, 2021, James Crumbley's 15-year-old son walked out of the boys' bathroom at Oxford High School holding a 9mm handgun. James Crumbley's son walked out, he pointed, he aimed that 9mm and fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. He killed 4, wounded 7, and terrorized an entire community. James Crumbley bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbley failed to secure that gun in a way to prevent his son from accessing it. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time. You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021. You'll learn that instead of receiving help or intervention of any kind, James Crumbley instead began to take his son to the shooting range.
That was big. The idea that he was the one, James, not Jennifer, James, who bought the firearm used in this shooting, bought it for his son just days before the shooting and failed to secure it, that this cable lock for the gun was never used. That's the allegation. Now, from there, Keese talks about what happened on the morning of the shooting. Before the son took out a gun and shot people, the Crumbleys were called to the school because they were alerted about a disturbing drawing their son made on his math worksheet. It was a gun with the words "help me." There were other alarming images as well. And more importantly, listen to what James and Jennifer didn't do.
James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6 Sauer 9mm. They didn't say anything about the prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting, though. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. James Crumbley spent the next 2 hours driving around town making deliveries. Never once bothering to stop by his house, which is just a mile away, to check on the whereabouts of the gun that his son drew.
Okay, so kind of reminiscent of what we heard from the prosecution's case against Jennifer Crumbley. A little bit different, though, for James, especially with his job that day. By the way, when I talk about these tough legal cases like the Crumbley one, I always think about the lawyers, okay? I think about what is it like to be in these kinds of cases. And the truth is, not all law firms are the same, especially in personal injury cases. If you're going to take on big insurance companies, you need a big firm, okay? Well, enter Morgan & Morgan. They are our incredible sponsor here on Sidebar. And as America's largest injury law firm, they're all about fighting for the compensation you deserve if you get injured. Because the truth is, if you get hurt, it is so important to see if you have a case. It is so important to know what your rights are, whether your injury could be worth millions of dollars. And Morgan & Morgan, they don't settle for lowball insurance offers. They will go to trial if necessary. In fact, they recently won massive multi-million-dollar verdicts across the country, including a $26 million verdict in Philadelphia. But I will tell you what I get really excited to talk about with Morgan & Morgan is how easy they make it for their clients. From submitting your claim to signing contracts to uploading documents to talking to your whole legal team. And yes, they have 4,000 support staff that can help you too. It can all be done from your smartphone. You can see if you have a case in just minutes. Oh, and by the way, there's no upfront fee. You only pay them if you win. So to start your claim now with Morgan & Morgan, go to forthepeople.com/LC Sidebar or click the link in the description and pinned in the comments. Then we heard from the defense in their opening, and here is Marielle Lehman.
The prosecution alleges that James Crumbley was aware that his son was a danger to others and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. He did not purchase that gun with the knowledge that his son may use it against other people. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? you wouldn't. Because you don't have any reason to think you need to.
So the argument is he didn't know what his son was doing. He had no reason to know what his son was up to. He had no reason to think differently. He had no reason to act differently. That's what the defense is saying. But we know that openings, they're not evidence. So let's actually get into some of the evidence in this case. So the first thing that the prosecution has to show is that a shooting took place and that there were people who were killed. So with that, the first witness of the trial, you might remember her, was Molly Darnell, who is a survivor of the horrifying Oxford shooting, and she was actually shot in the left arm.
Had you ever seen this person before?
No. At the moment that I locked eyes with him, we were standing square to one another.
Okay. Tell the jury about locking eyes with him and what you saw.
So I lock eyes with this person, and I see some movement coming from the side of him, and I realize that he's raising a gun to me, and my body reacted, and I jumped.
You're motioning. You're motioning that you jumped to the right.
I jumped to the right, so I'm jumping this way in the room.
And at this point, the door's closed.
The door is closed. Yes.
You jump to the right, and then
I jump. I'm turning and I'm jumping to the right, and then I feel my shoulder move back. It feels like I've been stung by hot water. It was so far out of what I knew to be what happens. And so I just knew that if I was bleeding, I had to put a tourniquet on.
It's chilling. I mean, I don't have a better word for it. It's just absolutely terrifying and chilling to hear this account. And also, it's a miracle that she's alive today and able to talk and testify about this. Now, from there, we heard the testimony of Detective Edward Wagrowski. He was from the Computers Crimes Unit. Now, he went through the actual text message conversations in this case and listened to this exchange from March 8th, 2021 between the Crumbley parents, and it gives you a little bit of insight into the family dynamic.
So let's go through this conversation. Blue from Jennifer, Ethan going to bowling. What's in green is James.
Correct.
What's the response there?
IDK, or I don't know.
And Jennifer's response, 3:12 p.m. Does he have his phone? Again, 3:12 p.m. Why isn't he home yet? 3:12 p.m. He should be home by now.
Correct.
Okay. And Jennifer at 3:12 p.m. and 56 seconds says freaking out. What was James' response?
He does not get home till 3:16.
And Jennifer's response, I told you to pick him up because he's upset and I don't want him to do anything stupid.
Correct.
That's March 8th at 3:13 p.m.
Correct.
Okay, and James's response?
Dude, period, chill period, he is fine, period. And I'm trying to work.
So it goes to that knowledge component. Did James have reason to know that his son was despondent, that his son was troubled? Now, he says he's fine. Maybe that could work to his advantage, the defense's advantage, to say he really didn't think there was an issue with his son. Or was he either not really paying attention, maybe he didn't care? Something for the jury to consider. Now, speaking of text messages, here are some from the shooter himself to a friend.
Tell us what the shooter wrote April 4th, 2021, 11:56 at night.
Types like I hear people talking to me. I see someone in the distance.
And April 4th, 2021, 11:56 and 50 seconds, what does he write?
I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up.
And 11:57 p.m., what did he write?
He continues on with, like it's at the point that I'm asking to go to the doctor. And then he says, my mom laughed when I told her.
That was again 11:57 in the evening, April the 4th, 21.
Correct.
April 5th, 2021, this is just after midnight. What does he write?
He tells his friend, but I'm having bad insomnia right now, RN, and paranoia.
Okay. And then what does he write?
I need help.
That's at 12:11 a.m.
Correct.
And then at 12:12 a.m., what does he write?
I was thinking I calling 911 too so I could go to the hospital.
And continuing on, April 5th, 12:12 a.m., what does he write?
But then my parents would be really pissed.
And finally, 12:38 a.m., what does he write?
says, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. And he continues with, but this time I'm going to tell them about the voices.
Now, to be clear, we don't know if the shooter actually had these conversations with his parents. It is evidence. It's up to the jury to weigh the significance of it, but it is important for the prosecution. Helps to establish that James Crumbley and his wife turned a blind eye, were willfully disregarding what was happening with their son. And speaking of that friend was taken to an out-of-state treatment center, which sent the shooter into this isolated downward spiral, and allegedly James knew about this too. But I do want to highlight one more major piece of evidence that came in on day one of this trial, the 911 phone call. And it kind of ties into what I just was talking about. So James Crumbley is notified about the shooting at about 1:09 p.m. He tries to call his son, no luck, speaks to his wife, then races home and calls 911 at around 1:30 p.m.
I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to the high school. I have a missing gun at my house. I need an officer to come to my house. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a text paper, and then I was in town, and I saw a whole bunch of cops going somewhere, and I made sure that I wanted to get to the high school, so someone was going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to go find out, and I think my son took the gun.
So why is this important? I think this is important for two reasons. One, it shows, first of all, he probably should have checked for the gun immediately after having that meeting at the school. Chose not to do, had the ability to do it, didn't do it. But I do believe that it kind of ties into a more important element, the knowledge element. If he really had no idea that his son was capable of this, of being a school shooter, if all of this came out of left field, does that add up with James, right after news of the shooting broke, rushing to check for the gun and call 911, thinking his son is the shooter? Something to think about. We are obviously going to continue to follow this case for you here on Sidebar and on the Law&Crime Network, where we're doing our live stream of it. So hope everybody can check that out. That's all we have for you here on this episode of Sidebar, everybody. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.